and I call the member for Warringah.
Thank you, Mr Deputy Speaker. I rise to support the Family Law Amendment Bill 2023 and the Family Law Amendment Information Sharing Bill 2023. These bills address recommendations made by the Australian Law Reform Commission final report made some time ago now, and implements elements and recommendations made by the Joint Select Committee of the Australian Family Law System. The bills aim to simplify the framework for determining parenting arrangements and moves to ensure promotion of the best interests of the children. Now, I should say at the outset, this is an incredibly difficult area of law in Australia. And this is actually an area of law that has had the most number of reviews and report over a significant number of years that successive governments have really failed to implement. So I do commend the government and the Attorney-General for bringing forward these changes. It's a difficult area to get right. This is highly emotional and highly personal for those that it impacts. In November 2021, I commended to the House the third interim report and the final report tabled by the Joint Select Committee on Australia's Family Law System, of which I was a member. And during the course of that inquiry, we heard so many distressing stories, accounts from men and women who had gone through the system and it had let them down, children who had been impacted by the system. And so it does befall on the government and this parliament to ensure the system works better. I called on the government to actually act on these reports because, as two previous reports from the committee and the ALRC recommendations, they had just been sitting on the shelf like so many others from previous inquiries. So I am really pleased to see these recommendations come forward. The breakdown of family relationships is often one of the very first interaction with the court system that individuals will have, and it's incredibly confronting. It's very difficult and emotional, and so many in the community are turning to the inquiries and these changes and looking for the implementation of recommendation, and they feel that there can be progress in such a distressing area. And even in circumstances where it may well be too late for their circumstances, they want to ensure that for others it is a better process. Before coming to this place, I was a family law barrister for some time. I had the experience of acting for both women and men and children in those proceedings. I know how distressing this area of law can be. It goes to the core of people's lives. And there's a really important element in that, which is time that you cannot get back and the time that it takes for these proceedings to be resolved. Now, of course, family law involves property and parenting, and it's, whilst one is your financial circumstances, the other is incredibly personal because it is your family relationship and your opportunity with your children. And as time passes, we know children are only small for a very short period of time. And so that's why the importance of a system to work in a timely way is so incredibly important. I would hope that there is a time that we actually approach family law and separation and breakdown of relationships in a bipartisan way. Because when politics get involved in these issues, you see a real weaponisation of people's emotions and people's fears and people's distress. And I don't think that ends up in really good outcomes. We know that with bipartisan approach to this, we can create a system that will be fairer, that will implement recommendations from experts, and we hopefully can progress this area. Sadly, modern society, over 40% of relationships end in separation. And while many of those separations are conducted fairly and amicably, there are still many Australians who rely on the family law system to settle their divorce or separation and resolve disputes around property and children. Some 3% end up in court for resolution, and that's 3% of separations are the most acrimonious and where there is that breakdown of communication and an inability to resolve. Most of us know someone or personally have been through separation and the family court process. To varying degrees, this process is adversarial, confrontational, emotionally unsettling, financially crippling and life-changing. If there's one thing we can't get back, it's time. And it's one of the major problems with the system, which reviews and reports have repeatedly said. It's imperative that our family law system be functional, but it needs to be fair and it needs to be well funded. And it all goes to that question of time, because time it takes for disputes to be resolved, to be determined. They allow disputes to fester. It allows problems or cracks to get wider. You can't make up time if you haven't had that opportunity to spend time with a child. So the key issues identified in past reviews were the costs associated with the family law system. And I know in that respect, many people have provided evidence, have often looked at family law practitioners and barristers as being a part of that problem. The difficulty is actually with the time, because the more a dispute goes on, the more expensive it gets. It's also maybe the makeup of how we approach family breakdown. It's the adversarial nature of the family law courts and whether we should move to a more inquisitorial model. Now, I know that is a very difficult thing to achieve, but there have been incredibly promising trials of less adversarial processes where we're looking at bringing people together to find the common ground rather than accentuating the dissent and the areas they disagree on. The issue of distressing delays in the current court system, the role of family consultants, it's incredibly important. Again, this is an area of law where it becomes a judicial officer has to break it down and come to a view on what will be in the best interest of the child according to the versions of various parents. Parents often know the child best, for example, but it comes down to one person's word against another. And that can be really difficult, and that is where experts come in that have a slightly less vested approach. They can have a bit more perspective. They understand, I guess, the research and data around best interest of the child. Expert witnesses, independent children's lawyers play a huge role in the family law system. From my experience in practice, the independent children's lawyer has a huge sway over the ultimate outcome, and it's important that they be well funded, that they be well qualified for the role, but also that they properly represent that independent view of the child, but also the best interest. Enforcement of contraventions and family law orders, this is a vexed and wicked problem with the family law system, because as much as the judicial officers will come to a view and determine final orders, they do not step out of the courtroom and go into people's lives. They do not go and see and make sure that people are actually complying with what the court has ordered them to do. And the whole structural, maybe, soundness of the system relies on people actually complying with orders. And you can't just call police and you can't call everyone out every time there is contravention. So enforcement and contravention of family orders is a very difficult area and a very frustrating area when you balance it with the other factors of cost to get to orders in the first place. And then, of course, family violence, because in family law proceedings, how the family law system and family violence jurisdiction interact is incredibly important, and it has been quite vexed. We have real dysfunction between at local court level when it comes to ADVOs and protection orders, and how that interacts and impacts family law proceedings, especially around parenting. And there's a lot of poor advice. There's often a lot of misunderstanding of the process, and this adds to the vexation and the frustration with the system. I would have to say there's a lot of misunderstandings around this system as well, and there's a lot of, I think, sometimes glib statements that are made for political reasons that don't actually reflect the law. And so it's really important to try and take the emotion away and actually look factually at what the law provides. So what the bill is addressing, I do support, but I have got a couple of areas where I raise concern that there isn't sufficient clarity, and will propose amendments to that effect, but also note with discussions with the Attorney-General that these will be considered hopefully during an inquiry process. There is misunderstanding of the presumption clause to reinforce the best interests of the child are paramount. So I do welcome that the legislation is repealing certain provisions, sections, and making clear and placing the best interest of the child as a paramount consideration in parenting orders. And it moves away from the often misinterpreted shared parental responsibility provision, because people misunderstand that to equating to a presumption of equal parental time. To be fair, the wording is not clear. The wording leads to that misunderstanding, but it's really important and hard to explain to parents. This is not about your right as a parent. This is actually around a child's right, what is going to be in the best interest of the child, to form a relationship with both parents, but also to have a more stable life, to be a child, to not have to just shuffle around. So it's really hard often to explain that, but really important to make clear that that is the centrepiece of the law. So I do agree with these proposed amendments, which simplify the list of best interest factors that a court must consider in making parenting orders and taking away that initial presumption. Because that presumption around shared parental responsibility carried with it that presumption of consideration of shared and equal time or substantial and significant time with each parent. And that essentially was superseding that consideration of best interest of the child. I agree with introducing a standalone test for the best interest factor for Aboriginal and Torres Strait Islander children, which will require the court to consider their right to enjoy their culture and expand the definition of family to align with their culture. This is incredibly important. I had a number of cases where we had to address this issue, and it is challenging under the way the legislation was to truly bring into the courtroom that consideration of those factors and give them due weight. I should say, though, it is not just Aboriginal and Torres Strait Islander children where these factors should be considered. I believe there may well be an amendment and consideration and inquiry that this is actually really important for other children of migrant background, where cultural factors are incredibly different. We are a very multicultural society, and there are different expectations and cultural traditions that really need to be considered for a child for their best interest, because the best interest of the child is for that particular child before the court. And so their cultural identity, their background is incredibly important. I welcome, in respect to the codification of rice and aspirins. So for those non-practising rice and aspirins, was the test established in a court decision that if once final orders have been achieved in a parenting dispute, what are the circumstances when a court can be asked to re-look at those orders? Now, keeping in mind when a court makes final orders in parenting disputes, they are taking into account factors right up until that child turns 18. So just a child ageing and growing up is not in itself a change of circumstances. We have to be really clear about how this works, because parties go to great expense. They go to great emotional distress and anxiety to get to final orders. It is often the result of years of dispute and litigation. And so to then be dragged back to court within 1 to 2 years by a dissatisfied party is incredibly counterproductive and distressing, and against, I would say, the best interests of the child. So I welcome this amendment that is codifying the factors of rice and aspirant, but I am proposing I will move an amendment to make very clear when these factors should be considered. So it should be as a interim hearing. It should be a threshold test that you consider whether or not there has been substantial change in circumstance before taking the parties down the road of a significant additional final hearing. I welcome family consultants having additional powers in relation to the implementing standards for family report writers to improve their quality, and the requirement for independent children's lawyers to speak and meet with children. I think it's really important, the parental responsibility, which is in relation to long-term decision-making and how that should be done. And I think, again, there should be a requirement that not just to consult, but to make reasonable efforts to consult. I think in relation to family violence, there is still much work to be done, but enhanced information sharing which will support the family court's responsiveness to instances of risk and family violence, child abuse and neglect is important. Enforcement is a massive area of frustration, so I do welcome the amendments that make it clear the process, a special list for consideration and the orders that are open. Now, there is still some room for improvement, and that I will address with amendments. I welcome that there is going to be a review of the merger of the courts, and that will be brought forward by 2 years to ensure the restructure of the courts and the new structure is providing families with a safe and accessible, efficient resolution of family law disputes. I understand that the Attorney-General has more There are more recommendations to be implemented in this area, but I really call on my colleagues here in this place to try and approach this issue in a bipartisan way for the welfare of parties involved. Thank you.
I thank the member. It being almost 1 p.m.